My name's Chris Pike. I'm the General Manager of Placemaking and Environment here at Council. I head up a portion of the organisation that includes the planning department. I've got a couple of colleagues here today and we'll take you through the session this afternoon. I'll be your MC for this session. Before I go any further, I'd like to acknowledge that we're standing here today on Wadawurrung country. I'd like to acknowledge them as the traditional custodians of this land and pay my respects to their elders, both past and present. So thanks for making the effort. We have a combination of people here in person. We've got a packed council chambers. We've got a number of people online, and hello to those who are joining us online. Around 40 to 50 we're expecting online, and we'll also have people who will be watching the recording of this at some point in the future, so g'day to you too. Before I go any further, we do have hearing loops here, so they're on the table at the back. We've got staff that can assist you if you're hard of hearing. Please see the council staff at the back that can assist you. Just a couple of other things. If you are watching online, you're not going to see a visual spectacular in terms of sort of human movement. We've got a fixed camera. We're going to mostly have the presentation slides up, so hopefully that's a decent experience for you if you're watching remotely. But I just asked those online, and I assume we won't have a problem here, but please ensure that your microphones are muted. Occasionally people forget that and we get a conversation in the background about a cup of tea. And if you're not familiar with Teams, and I appreciate that some people might not be, you're just looking for a little microphone icon in the top right of your screen. As long as you've got a line through that, you are muted. Okay, so we really hope we've allocated an hour here. We hope it's going to be a useful session to provide some information about the applications affecting the Sands. Shortly, I'll introduce a couple of colleagues here who will do most of the talking in relation to some information we're keen to share with you. We've had some pre-submitted questions as well, and we've allocated time to receive some questions from the floor and those online as well. We know that. Okay, so if you could just put yourself on mute as someone joining us online, that would be much appreciated. So we've got some quite complex planning applications. We know this is of great interest to a lot of you, hence you are here. We'll do our best to provide some information that's going to assist you. Our aim really today is in 3 or 4 parts. So we would like to take you through the history of the Sands from a planning perspective and explain how this impacts the current controls and the applications that are before us now. We'll attempt to give you an overview of those 3 applications that are up for consideration. We'll thirdly highlight where we're up to in the process, and fourthly outline the next steps and how you can have your say along the way. So this session is really about the process for those applications, so you've got a really clear idea of what to expect as we head towards a decision being made. Now, I would like to sort of call out that planning application processes can be foreign to a lot of people. It might be the first time that you've encountered that. They can feel quite stressful for people. There can be a lot of questions and uncertainty. You might be attending online or in person with holding some emotion about those applications. And the planning process is complicated, full stop. So I'm really hoping that by providing some information about the process, we can be of particular help to you this afternoon. What I do need to be clear about, though, is that this session isn't a discussion about the merits of the applications, and hopefully that was clear in the information that invited you to this session. That opportunity will come later in the process, and we'll talk about where that sits in the timeline. I do want to apologise in advance because I will be a bit strict on that point during the questions and answer session. It really needs to be an opportunity to tease out uncertainty about the process. We can't enter a discussion and receive comments about the process itself, how you might feel about it. Sorry, not the process, the merits of the application. And we won't be in a position to talk to you about what we think about the merits of the application too. We really want to focus on the process. Couple of housekeeping matters. If you do need the bathroom, just out through the sliding door and to your left. and there is tea and coffee and water available. Because it's quite full in here, it might get quite warm. If you do need to get up and stand onto this at the side of the room, please do what you need to do. So with that said, I'm going to hand over to my colleagues from the statutory planning team who are going to take you through most of those points that I covered earlier. Just to introduce them, to the left as you look at them, and he'll speak second, is Rob Wandell, our Manager of Planning and Compliance. And then we also have Ben Schmid, who's a Principal Planner in our statutory planning team, and I'll hand over to Ben in the first instance. Ben.
Thank you, Chris. And good afternoon to everyone. Just to start with some planning history of the Sands and how we've got to the point we are at today. Planning for the Sands, some development on what is now the Sands, really started in the mid-90s.
All right. Okay, can I test again? Can anybody online hear us?
We can now.
Yes, okay, all right. Thank you. So is this the first audio you've heard online?
No, we got up to the start of the history of the Sands.
Okay, perfect. All right, so we're good. I'll hand back to Ben. Thanks everybody for your patience.
Sorry about that. Yeah, so I will quickly recap. So I was saying that the first planning for the Sands land really started in the early mid-90s with a proposal for a Golden Beach resort, more of a tourism focus than we see with the Sands. That was overtaken in the late 90s with an amendment, R60, for residential lakes and golf course estate, quite similar to what we have now with the Sands. In 2000, we had the introduction of a new Surf Coast planning scheme, and that included rezoning the land that is now the Sands to the Comprehensive Development Zone, with Schedule 2 applying. In 2001, the Sands Comprehensive Development Plan was approved, and that plan, with some subsequent amendments, continues to be the current development plan applying to the land. In 2001 and in the years subsequent, planning permits were issued for the development and subdivision of the estate, and we're seeing that development be undertaken, and the resultant development on the land is largely consistent with the development plan approved under the zone. There have been some amendments to the zone in 2005. Amendment C19 allowed for an increase of 100 residential lots to accommodate the residential hotel that's present on the site now. In 2019, 2005 again, following Amendment C19, the Comprehensive Development Plan was amended to reflect the residential hotel being a component of what was now permitted under the zone. And in 2019, there was an amendment to the plan to shift an area of medium density precinct on the corner of Sands Boulevard and Pacific Drive from medium density to residential precinct. And finally, in terms of history, in 2020, Amendment C130 made changes to the zone to deal with the removal of the Architectural Review Committee process and brought those controls that were being dealt with by that committee into the zone. There were some other more minor, or I would say, changes to the zone to reflect the requirement that when you undertake an amendment to the zone that you are required to be consistent with ministerial guidelines around the formatting and content of zones.
Shit.
I'm just trying to get this moving on. Sorry, someone, do we have a mouse available?
I'll have to go out.
Yes. So under the present day, we've still got the Comprehensive Development Zone Schedule 2 applying. For those that aren't familiar with the Victorian planning system, zones are essentially state controlled. The state sets what the content of the zone, but what council can use is the schedules to zones to bring in local content, local variations, and in the case of the CDZ, it's a very localised zone compared to, say, a general residential zone that might be found across other parts of the Shire. The Comprehensive Development Zone works in conjunction with an incorporated plan, and the incorporated plan for this land is the Golden Beach Concept Plan that was considered back in Amendment R60 back in the late 90s. So that document is what we call an incorporated document. It sits outside the planning scheme, but it operates as if it is part of the planning scheme. And so we are required to have consideration of it. And as I say, it continues to be incorporated into the scheme. The Schedule 2 to the zone, in this case, includes a requirement that before any development or any subdivision occurred, that the Comprehensive Development Plan needed to be amended. It needed to be amended to reflect recommendations from Amendment R60, or the panel report from that amendment, and to reflect the requirements of the Environmental Management Plan that applies to the Sands land. As I mentioned before, the first variation of that plan was approved in 2001, and there's been only a couple of minor changes to that plan since that time. The same provision that required the current plan to be prepared and approved also provides that the plan can be further amended to the satisfaction of the responsible authority or council. And that is the first matter that we're dealing with the 3 applications that we've received. The zone requires that most use, development and subdivision must be generally in accordance with the development plan. Now, generally in accordance is a principle in planning that has been subject to legal review, and there are some principles that come out of the case law around that. As the wording suggests, generally in accordance doesn't mean exactly in accordance. There's some flexibility. And the case law principles tell us that that flexibility is to be applied having regard to how detailed the plan is that you're considering. So generally, the more detailed the plan, the less flexibility that is available. There are more principles that I won't go into, but that's the sort of general approach that we need to take in this matter. So for this application that we have, council needs to continue to be satisfied that the amended development plan is generally in accordance with the Golden Beach concept plan. Some other key features of the zone are a maximum of 700 residential lots and 700 dwellings. And of those 700 residential lots, 100 of those must be within the commercial precinct, which is an area generally around the golf club. If I jump to the next slide, I'm sure you're all familiar with where the golf club is, the clubhouse, but that area on the east side of Sands Boulevard, the colours don't come up great on that slide. They're all shades of red, but I'm sure you understand where I'm talking about. So the other 600 lots are spread across the other residential areas. And again, I'm sure you're all familiar with where those residential areas are. There are a number of overlays that apply to the land, and I've got a list up there. Largely, those overlays are concentrated over the eastern part of the site, around the edge of the wetlands, sometimes a buffer distance beyond the wetland itself. The exceptions are the Development Contributions Plan overlay, which applies to the whole of the land, and the Bushfire Management overlay, which is concentrated to the southern boundary. But it does come into play. So the case is that on residential land, so in one of the residential precincts, it is possible that a dwelling can be constructed, one dwelling on a lot can be constructed, without needing a planning permit. Within the zone schedule, there are a number of requirements, which if all of those are met, means that you can proceed without getting a planning permit. If any of them aren't met, a permit becomes required. And the other thing to note at this point is that land outside of the site to the south, so the area of the esplanade adjacent to the site, is in a public conservation and resource zone, which becomes relevant when we look at the planning permit triggers later. So you probably are very familiar with the fact that we have 3 planning permit applications in play. And the first of those is to amend the Comprehensive Development Plan, primarily to increase the number of areas that are available for residential development or subdivision. The second is to then proceed to subdivide those additional areas, if the plan gets approved, into residential lots and a balance lot for the golf course. And the third is to develop one of those lots, one which is proposed to be created to the south of the clubhouse, to use and develop that lot with 9 dwellings and to subdivide those dwellings onto separate lots. In terms of the middle of those, the first subdivision, that application is subject to, I think it's 8 planning permit triggers under the zone and under the overlays that apply to the land. Additionally, for the removal of native vegetation and also to construct works on land in the public conservation and resource zones. So that bit of land outside the site, council-controlled land, where it's necessary to construct access into one of the proposed areas. So stepping back to the application to amend the development plan, the reality is that the Planning and Environment Act doesn't provide us a step-by-step process to follow to determine or to assess and determine that application. So unlike a planning permit application where the Act tells us that we must give notice of the application, that we must refer the application, it is silent in terms of considering a matter that's to our satisfaction. So it means that there's no statutory requirement to give public notice or to refer the application. However, what Council's approach is to publicly exhibit the application. So as you're aware, we've put it out and made it public and informed the owners and residents within the Sands and of surrounding land that we've received this application to amend the plan. And we've also sent it to external authorities that have expertise or could have an interest in the application. So it's Surf Coast Council's view that it is important to hear from the community about your concerns about this application to amend the plan and to get that expert input from authorities. In relation to the 2 planning permit applications, as I said, the Act sets out what we must do. So we have given public notice, formal public notice, and we've formally referred that application. It is worth noting that the Act enables the planning scheme to create exemptions from notice for certain types of applications. Some of those exemptions are beyond council's control. They're set by the state through what the state standard zones and overlays state. And so it's the case with the subdivision application, the first subdivision application, that the only planning permit triggers that we are required to give notice of are subdividing the land in the environmental significance overlay, the removal of native vegetation under clause 52.17, which is a particular provision that protects native vegetation in Victoria, and for the works on land that's in public conservation and resource zone, so the council land. The other matters that are under consideration in that application are exempt from notice. And it's somewhat similar in terms of the application to use and develop dwellings, that the use of land is the only trigger that's not exempt from notice in that application. So having carried out both the combination of informal notice and the statutory notice that we're required to undertake, we have received a large number of submissions represented by the large number of people that are in attendance today. And we've also started to receive input from external authorities. And I'll hand over to Rob now to talk about the steps that we'll take moving forward. Thank you.
Hi, everyone. My name is Rob. I'm very glad to see you here today. So my role from here, Ben, is taking you through the planning background, the history. If you feel after that speech that you are across the planning law and you are now an accredited planner, just bring me your CV on the way out and have a chat with me, please. If you're considering a career change, we'd love to hear from you. As you could tell, it's quite complicated, and there are a few things definitely going on. And if you, the point that I would like to bring up is, if you don't feel confident after that, you know, 15 or 20 minutes of trying to condense a pretty complicated matter, we are available to chat anytime, and please reach out. So what I'm here to guide you through now is that's the history and the context of the applications that are before us. I'm here to outline for you what that means in relation to your future participation and how the decision itself is made and the decision-making process. So in the first instance, I'm just going to flick up this graphic to show you visually what we're up to now. So right now we're at this session, which we're calling a community information session, which, by the way, we've never done before. We've heard some of your comments to say, why wasn't this done a little while ago? And we take that on board. We haven't done it before, and it's a trial for us, and I think we're responding to the amount of concern that we're hearing out there. From here, where we go after this session is that we will have what's called a hearing of submissions. I'll talk about the detail of that in a little bit. That is now scheduled for the 7th of July, followed by a council meeting. We have posted that as very likely to be happening in July, but we'll just put out that a lot of things still can happen. For example, including the amendment of the application, should that occur. So we've posted that as our guide for when we're anticipating that is to happen. We'll talk you through the timelines and how we're anticipating that could work, but we'll just put the caveat out there that things could change. The little disclaimer on the bottom there is just to tell you that, so as Ben alluded to, there are 3 different applications, and the 2 of them must necessarily follow the first. So the decision at the council meeting is only in relation to the first one. I won't go into the intricacies of why that is, other than to just say we have what's called an instrument of delegation. And the instrument of delegation just indicates who has the delegation at council to make certain decisions, where in this case, the development plan decision, when there are unresolved submissions, must be made by councillors, which is why it is going to this public forum at the council meeting. Based on that, I will dive into the hearing of submissions and what that's all about. We at Surf Coast Shire Council don't do too many of these hearings of submissions, so it's quite possible that you have never seen this process before or know what it entails. And it's and I'm hoping just to give you an indication of what to expect should you want to participate in that forum. I'll probably start the conversation by saying this is not mandatory. So in other words, it's not a requirement for anyone who has given a written submission to then get up in front of councillors and give it verbally. It's just a tool for you and for councillors both to be able to hear verbally your submissions should you be inclined. Most of them that we've done in the past have involved in the order of 4 or 5 different parties, and we're anticipating, obviously, with the interest that is here, that could potentially be more. So there'll be some written directions and some correspondence that we'll send out to you in relation to potentially, you know, how you might go about doing that and what would be most effective so that we can get through that session and it be useful for everyone. So that's a bit about the purpose. The format, if you haven't been a part of that, again, so it's called a special council meeting. So it is a formal meeting of the council, and it does follow a little bit more formality in relation to its nature and its content. So we try to we do pre-register those who are looking to make a submission, so we understand who's looking to participate. And then the timing of that is quite formal. So you're given, is it 4 or 5? 5 minutes, I believe, is the time. And so there is sort of a formal countdown and a tracking of that time so that we can make sure that we stay on task and stay on time, and everyone gets a fair amount of time to be able to present their case. We have heard the feedback at times that sometimes that can feel a bit one-sided, and it is. So councillors in this case cannot ask leading questions, and there is no opportunity for dialogue. It is set up as a formal process for you in intentionally fairly one way in relation to you have an opportunity to verbalize your submission. Again, you're not put at a disadvantage if you don't choose to do that, and the councillors will still have your written submission on file and have read it. Yep, that's a good point. So you'll see at the top there, this one is entirely conducted online. And there will be directions, written directions in a letter coming to all submitters shortly that indicate how you do that. That one is done on a Zoom format, and you'll be taken through that in the written instructions about how to participate. Oh, it's already gone out. Those letters have been sent. Yeah, well, I'll keep going. It's a fair question. We'll collect the questions for the end, and maybe Chris will just note that one in relation to why the question, in case anyone didn't hear it, is why is that only done online? From the hearing of submissions, we move to the council meeting, and that's where the decision is verbalized. So this, again, as I've told you, we have penciled this in for the next ordinary meeting, which is the 28th of July at 6 p.m. The council meeting is done in a hybrid format. So in other words, you can attend in person and you can view that online as well. And by the way, it's similar to this session, you can view it at a later time as they are recorded. So the notes in relation to the council meeting is that there have been a fair few questions in relation to how do councillors come to that decision. And so I'm confirming here that council officers will prepare a very detailed and comprehensive report and recommendation in line with how we make any decisions here. And that report is made publicly available in the agenda before the meeting. So I think it's the Friday before the meeting. That is available via our website, and you're welcome to download that report and read it and understand the recommendation and read all the details. As per the Planning Environment Act, planning officers or anyone that's acting as the responsible authority must include in their assessment any of the written submissions. And so part of that assessment and part of that report will be an accounting of how we have viewed the submissions in relation to the requirements of the scheme. So the confirmation is that councillors will definitely have read that report and be informed by the officer's view. They will equally be informed by your written submissions. As mentioned, the hearing of submissions will have happened just a few weeks beforehand, so they will also be equipped by your verbal submissions should you have given them. The other thing worth mentioning is that some of you may have seen councillors out on site. Councillors have taken quite an active view on this one and have conducted their own site visits at a variety of different times. And so they understand the context and have been on site. At the council meeting, council will make the decision via vote in relation to whether the amended plan is approved or the existing plan remains. And I'll give you a graphic on the next slide in relation to what that means in terms of where we go afterwards, where one of those two decisions will be made. And again, just the bottom note is just to indicate that councillors are meant to be making this decision as the responsible authority in the context of the Planning Environment Act. So they are meant to be looking at the same requirements that a council officer would in order to come to that decision. Okay, brief pause there. So there are two outcomes that are possible after the council meeting. The first outcome is a vote to say that councillors are satisfied that the amended plan should be approved. The alternate being that they are not satisfied. In the case that they vote to say that the plan is that they are satisfied that the plan should be approved, that amended plan then immediately becomes the approved development plan. The important part here, and Ben tried to break it down, and it gets quite complex and convoluted, but the general advice that we're giving or our view on it is that there are no general appeal rights for submitters if this decision has been made as it relates to the development plan. We're happy to talk you through that. You may have your own views and your own advice in that regard, but the general stance is that those satisfaction matters are made, and an appeal isn't a necessarily automatic outcome as it relates to the development plan. If that is to occur and the submitted plan becomes the approved plan, then we can proceed to decide the planning applications. The delegations are such that the planning applications can be decided by council officers, and we're assuming at this stage that if that were the pathway that it was to take, in other words, that the plan were to be approved, that council officers would then go through the usual process in relation to the planning applications. Conversely, if the plan is not approved, the applicant in this case does have appeal rights and could review that decision at VCAT. All right, there's a lot there. I can see a lot of stunned silence, and so I'll turn it over to Chris to lead us through the questions and answers.
Thank you for that, Rob. So, okay, so look, I hope that provides some background to you. I would call out the fact that I can appreciate that a number of you here would want to engage in the substance of the matters, and hopefully we've outlined exactly what the process is for that in the next few weeks. We're going to take questions from the room in a moment, and if you're online, feel free to use the chat function to table those. I would make the point that should we run out of time, and that's a possibility, then we will, the planners are absolutely happy to take a phone call at any time during business hours and to have that conversation with you. We are recording this. You are not visible. Well, the backs of you are visible, for some of you are visible, but if you didn't want your audio heard again, feel free to use that phone call method. We have had some sort of pre-submitted questions, which Rob will handle first. There's just 3 of those. And I think that's kind of it. Before I throw I'll throw the questions in a second. We'll take the pre-submitted questions. I will answer that question that was posed earlier in terms of like, why do council hold their hearing of submissions meetings online? That's been the prevailing practice. It changed during COVID, as a lot of things did during COVID, and council's experience to date has been that that's a process that enables greater involvement of people rather than less. The feedback through the hearing and submissions processes that we've run is that that seems to work okay. It has to, I have to say, in that period, there hasn't been a matter of this kind of size, and so I could appreciate why there might be that question. But to date, council, the last several years, council's been running those online. That provides an opportunity to run through and hear from everybody who's participating, including those who can't be there on the night. Rob, we've got some pre-submitted questions, and then I'll manage questions from the floor.
It's possible that we've covered some of this in the material already, so I'll try to be brief in relation to this, but oops, I got that wrong. There you go. So there were 3 questions that were submitted beforehand, and almost all of them relate to essentially just questioning whether council is aware of the background and the history. And so the quick and easy answer to any of these is yes, we're aware, as you've heard with Ben's presentation of the history. We're aware that the comprehensive development plan needs to be approved first, and again, it adds this layer of complexity that we're all aware is hard for everyone to get their heads around. But we're definitely aware that the comprehensive development plan would need to be approved first, which is the first question. The second question just then relates to the Golden Beach concept plan, which is the approved plan. So again, the concepts of generally in accordance with, Ben went over those, and we're definitely aware of how that operates, and that again will be part of the assessment that anyone can access before the council meeting. The third question relates to a related document that some people may have seen, which is the guidelines for the conversion of golf course land. This is a state government document, and this occurs a lot in the as it relates to the planning scheme. The planning scheme, as our statute indicates, the requirements that we're meant to consider, but there's all sorts of other material that becomes useful and germane to the assessment. We are certainly aware of these guidelines. In terms of what weight we give them, we'll outline that in the assessment as it is to come. But I guess the quick and easy answer to that is yes, we're aware of them, and yes, we would agree with the comments that they provide a useful framework to operate within. I'll turn it over to Chris.
Yeah. So we have a Robin, if you can just wave, sort of over here. It's got a microphone. We will use the microphone if you're asking a question so that it's picked up from
testing
online. Yeah, so we've got a first question here. I might ask you guys to step up so that we can
Thank you.
be efficient.
I would have suggested that the first question everybody should ask is, why are we doing all this? And that is the administrators that are actually have been put in place at the Sands to recover any debts that the Sands actually holds. Now, there's 21 actual properties, as we know, and there's 9 on the proposed on the tennis court. Now, obviously, some of these properties will affect some people more directly than other people. For example, the golf course, it'll affect the views of what the person or people are enjoying at the present, and have no doubt purchased that said block of land some time ago with a view of enjoying whatever they're enjoying. The same with the other 21 said pieces of land. They're not going to enjoy the foliage and the nature of those plants.
Could I encourage you to bring that to a question, because I understand that there's a comment that you...
Well, why are we doing it? Is it just to raise some money to pay these administrators first, because they're going to be, their mouths in the trough are going to be first, and then secondly, whatever debts they owe to the bank.
Sure.
That's really why we're doing it.
So the answer to why we are here, and I'll invite any additional comment. Anyone is entitled to put in a planning application about any use of land in the Shire, and council has an obligation to consider that application. So it doesn't get to whether what's being put forward is appropriate or not. That's not ground we're going to cover today. The reality is council has an obligation to consider the application. That's it. And so commonly in the planning space, we can receive questions from people who are frustrated that council's even considering something. The reality is we are obligated to consider it, and people are free to put in an application. And so that brings us to where we are today. Yeah.
Just before we go on, we've got some on the chat. So Susan.
We'll alternate, okay?
Yep, testing. So we've got two on the chat. One is, can you explain why the applicants can appeal the decision but not the objectors as outlined in your last slide?
Yep.
This is a slightly complicated one. The appeal rights for a satisfaction matter are different to a planning permit application. So they don't refer to objectors because the application is not subject to formal notice. The appeal right is in relation to the decision of a specified body, and council's one of those specified bodies. And the appeal right arises for a specified person. And did we have that on the slide? I think we did. So the specified person on the third dot point down is the owner, user or developer of the land directly affected by the matter. And so it raises the question of who's directly affected. We know the applicant is directly affected by the matter because they're seeking to use and develop the land in a different way. The question becomes, does that extend beyond anyone beyond the applicant? We're not legal experts, so we can't provide you that sort of exact advice, but it is potentially open that those that are affected by the development plan could have a right of review, but I guess we need to encourage you to get your own advice to understand whether that's correct. If it was a matter of someone without standing sought a review at the tribunal would essentially carry out a hearing to determine whether you had standing to make that application.
Thanks, Ben. And sort of nestled within that, the complexity of that response is council's operating in a framework of state government rules, essentially, with some local content. So a lot of this is dictated by what the rules are and how they're applied across the state. And that's not something that we can deviate from. Okay, we've got another question in the room.
Yes, thank Rob's observation that that council officers are free under the instrument of delegation to determine the two planning permit applications, which would have to follow. I get that. I understood that council's instrument of delegation is subject to specified objection numbers, and that once a certain number of objections are received, that the officers no longer have delegated authority and must refer it to council. Is that understanding correct?
Little bit of a nuance on that. So council has, and you can see this on council's website, it's a thing called a calling in of planning applications policy. So it establishes the instances whereby on planning applications, whether officers will put a matter before council or whether council will do what is commonly termed as calling in a matter, so saying that the matter will be considered by them, and that has some parameters set in there about what are the triggers for when that might happen. The vast majority of our 500 to 600 planning applications a year are considered under delegation by council. It doesn't preclude, so I acknowledge Rob's statement earlier, the policy could be actioned either by officers or by councillors to make that decision as the council group rather than officers. So Rob's probably talking about what the normal approach is as opposed to what actually will happen in this instance. Yeah.
I don't want to be argumentative, but my reading of the instrument said once a specified number of objections are received, the matter shall be determined by council or called in by council, not straight to or called in by council. But in any event,
okay, all right, thanks. I'll take that as a comment. Yeah.
This group be very keen if it gets to that point.
I have no doubt. I have no doubt. And then we've got another question,
Susan,
from online, and then we'll come back into the room. We'll take one online and we'll come back to you, Susan. Yeah. Robin?
Sure.
Yeah, we'll go in the room and then we'll come to Susan.
The other ones in the room? Oh, I've got one at the back here.
Hi, Chris.
Go on, Jeremy.
I'd like to probably request that the format of the Zoom meeting on July 7th has changed to hybrid.
Yeah.
To enable a forum like this to happen. Is that possible? And if so, how do you go about that? Is that take a?
I'll take that back as feedback from today's meeting.
I'm sure if we had a show of hands, there'd be a consensus on that. And
well, yeah,
it's all about public participation with the councillors, and I think it's different for a matter of this size.
I do understand what I want to. So I will absolutely take that back to the councillor group and our an executive. The point I would make, if you do attend that, if it were a hybrid, so a version of what we have today. It is not a sort of an all-in meeting. It's processional. It does feel a bit processional, having sat through a number of these online and then going further back in person. It's a series of 5-minute verbal presentations to the councillor group. Invariably, because the presentations are fulsome and there are a lot of people to hear from, councillors won't ask any questions of each submitter. Not to say they're not interested, they could have several to get through. So, there isn't some back and forth just to manage people's expectations. It doesn't sort of turn into a sort of a town hall style debate. And in fact, the council meeting doesn't operate that way either. Next question, we've got one online.
We do have one more. Can you please be clear on the key assessment criteria that informs a decision? Is there a top 5? Do some criteria have more weight?
That's a difficult one. It goes somewhat to the merits. I guess the scope is broad. We do have to have regard to environmental considerations, character considerations. We need to look back to the Golden Beach concept plan, certainly, the environmental management plan for the Sands. Things that are coming into play are bushfire risk. You're probably all familiar with the carafe and the stormwater concerns there. So the considerations are very broad, and I wouldn't say there's anything that definitely narrows those considerations. There's nothing in the direction of the scheme to rule things out at this point in time.
So I appreciate that. In some ways, that's the $1 million question. How do you arrive at firstly, officers as a recommendation and then council at a decision? The way that will be most evident is in the written report from officers. So that will outline the rationale for whatever conclusion is reached by the officers. And then how do council make their decision? That the evidence of that is in the content of the debate that you would hear on the night, the various speeches and persuasive arguments that are made by councillors prior to making a decision.
I have a question over here.
You do, and then we'll take this later down in the red. Yeah.
I just had 2 quick questions. One, is it too late to expand on current submissions? First question.
That's a quick answer. So submissions can be made right up until council makes a decision. Obviously, earlier is better to give the officers time to consider, and certainly before the council report is written. But even if received after the report's been written, those would be made available to councillors.
Great. And the second question is the comprehensive development plan. I might be incompetent, but I tried to find it and haven't been able to find it anywhere. Is it on the planning website, or where would I find it?
It is on the planning website. I think the easiest way to find it when you go to Surf Coast's website is to go up to the search box up in the top right corner and search for 2 Sands, and you should come to a landing page for this application, and down towards the bottom in a list of documents, the current approval is there. If you have any troubles, contact us.
Thanks, Ben. We've got the lady in the red and then the gentleman in the grey top.
I just want to ask, if this agreement goes against the residents of the Sands, can we take it to VCAT?
Okay, well.
Yeah, so that goes back to the previous question, in that it's not certain about third-party appeal rights. So certainly the applicant has a right of review. It's possible that those within the Sands development plan area may do. but we can't be certain because it is a matter of interpretation, legal interpretation.
Susan, you have one online before I go to the gentleman in the cap.
Yes. Is the process the council will go through to consider those criteria going to be more thorough and directed at the specific objections submitted, or is the process typically considering all those issues despite the objections? Curious as to how thorough it will be versus how it might have been if no one objected.
Yeah, it's a great question. So there is some tribunal, I suppose, principles in relation to the number of objectors and whether that's meant to be significant. My reading of that is to say that the number itself is not meant to persuade you one way or the other. It is the summary of the grounds of objection and how that relates to your assessment against the requirements of the scheme. So I think if I'm reading between the line of that question, we're well aware of the number of objectors, and we have heard you loud and clear. I would like to believe that any of our assessments with any number of objectors does a fair job at not only just summarizing the grounds for objection, but going into detail in relation to how we viewed that ground for objection in relation to whether the recommendation should be made or not. So I think there's sort of two parts to that question. Is the number of objectors significant? We take it of the view that it's not really about the number, but the nature of the objections. But we take that matter quite seriously, and yes, there will be a fair portion of the assessment relating to how we assess those grounds.
My understanding is some VCAT hearings have been successful. If we did go to VCAT, would the applicant stop? It wouldn't go ahead until that meeting was concluded?
A bit about what happens, how might it play out?
Yeah, if I understand that question correctly, Austin, we can't know whether the applicant would participate. You can only assume they would. In terms of the two planning permit applications relative to the development plan application, I guess at this moment, council's intention is not to decide on those applications until the development plan has been amended. And so if there was an appeal afoot, I don't think that council would be intending to determine the planning applications until the appeal about the development plan was finalised.
One more question. How do we obtain the Golden Beach plan?
We can look at putting that online, but also if you want to email us.
Okay, we'll look at getting that added to the document library. I think, did we have one here next to the screen?
We've got one here.
One here, and then next to the screen.
And there's a gentleman with a hat at the back.
Will councillors be provided with a common rubric that they can use to base their decisions on, rather than some of them will be picking up on a selection of those issues and others on another? So they really won't all be considering the same set of issues to make their decision.
I think no is the short answer. So if I'm drawing on historical examples, officers will provide the council report. There'll be possibly a number of briefings leading up to that. And so these will be closed informal meetings with the councillors and officers, whereby it's an opportunity for officers to brief councillors on officers' thinking and to field any kind of questions that councillors want to pose. Ultimately, it's in the hands of individual councillors as members of the council to lean on the elements of the advice that they receive to ultimately make the decision. The advice provided by officers is to remind councillors that they're operating as a responsible authority. So there's always a temptation in planning matters to lean on issues that might not be relevant planning considerations. But ultimately it is in their hands, and this is where the evidence of the matters that they've considered in making their decision is really to be found in the debate that occurs on on the night prior to their vote. In terms of what is in an individual councillor's mind when they make a decision at that moment of raising their hand or not raising a hand, that's not something that can ever really truly be known. Having been involved in cases that have gone to the Supreme Court, ultimately it's within each elected councillor as a member of the council to arrive at their decision based on prioritising whatever they see is most important for them as an individual.
Excuse me, Chris. We have 5 minutes and the Teams link is going to expire. So I'm just going to throw to Susan for 1 minute. Are there any more questions?
There are no more online questions.
Okay, we've got one at the back, we've got one next to the screen, and then we've got one down the front.
So regarding the considerations for a decision, we've heard environment, character, stormwater and craft, Golden Beach plan adhering and a couple of other things, but there's nothing about legal considerations, as in when the Shire co-wrote the Building and Environmental Management Code for the Sands, which is a document all people who bought there were made to comply with at high cost, and it undertook to protect views, amenity and prestige of the estate for the long term. To me, that's a legal document we relied upon, that we bought something that we were reasonably able to expect would be upheld, and your name's all over it as a Shire. How can you walk away from that and say it's even can be considered that you would build a house in front of someone else's house, given that document said, with your stamp all over it, that you encouraged people to take maximum advantage of views available of the golf course and the coastal environment, and you undertook to protect it in the long term. So why is not the legal aspect a part of your consideration, that you as a council, as a Shire, made a representation to people which they've relied upon and will suffer significant loss if you go back on that? It'll be a false or misleading representation contrary to the Trade Practice Act.
Okay, so I would start by being very clear. We're in a planning process and no decision has been made. I acknowledge the fact that you're asking what are the things that council, what does council, but I understand that. We are in a planning process, and so the matters considered are those required through the planning system. Is that something that either you'd like to expand on?
Good towards class action.
Yeah. Yeah, no. So we're I'll take that as a comment, but we're in a planning process, and it's state government policy, along with local policy, that dictates what is considered in this planning process. Possibly the matters you're touching on are outside of a planning process and could be subject to two different processes. We had a question just next to the screen, and we had one down the front, Robin.
There is a late online question as well.
Okay, we'll hold that for the moment, Susan.
Yeah, I just a question. First, I want to make an acknowledgement. Thank you for running this meeting. You've been very professional. It's a difficult meeting for many people. I appreciate the fact that you've run the meeting in the way it's been run.
Appreciate the feedback. Thank you.
The second question is, I think it was a surprise to me when I discovered that all of this land that we assumed had been settled was no longer settled. I have a specific question about what does the council actually manage and operate within all of that land that's currently green on a plan? If we put up the slide that showed the golf course estate, for example, what is actually council owned and managed on the estate and what is not, because that's not clear to me in terms of the plan.
Okay, and without getting into absolute specifics, my understanding is that council's land management responsibilities are confined to roads. There are some open space, and there are, including trees, and there are, I think, some smaller bits of infrastructure like footbridges there. But that's it. That's the limitation of council's land management. There's some open space managed by council within that. We had a question. It is small. Like the vast majority is not under council management.
G'day there. Look, by what you said, you're doing things a little bit differently with this particular application because of the considerable interest in it. To help you guys and to help everybody in the community, there's a number of people that work, would probably like to be here.
Yeah.
Aren't here,
Yep.
and yes, they could watch the video,
Yep.
but then a number of them have young kids and,
Yep.
you know, they're pretty occupied. So because you're doing things differently, I think it would be really helpful for the community if you would put this into a one-pager
Yep.
with a timeline.
Yep.
And also the details of the fact that you guys are going to write a report.
Yep.
And that will be available online, and give a link to that.
Yep.
So that everybody in the community gets a one-pager or two-pager with all the information we've got today.
Yep.
And those details. And I think it'd help everybody, including you guys.
Thanks for that feedback. And we'll look at what we've got one pages and we've got the slides, and we'll look at exactly what we're communicating. You're right. The spirit in which we have approached this is it's complex, it's got a lot of interest, and better to provide a bit more information than not enough. So thanks for that feedback as well. Appreciate that.
Just to let you all know, we are putting a pack together, and I've listened to everything that you've said.
Thanks.
The pack's already in development, and the recording will go out either later this afternoon. It'd be good to try and put a map in there of council managed land, and of course,
Yep.
if I can get that together, I will. Otherwise, that will come as a secondary piece for you. But we'll put everything on the planning website that we can to backfill anything that's missing.
I'm going to take a final question online. Just fair to say, if you did want a cuppa as we wrap up, feel free to do that. Rob and Ben and I will stick around for a few minutes. We won't be talking about the merits of the applications. Just as a word of warning, it's not some special session. Okay, from the online chat.
As part of governance, are councillors required to document how they come to their decision?
So document, no. I mean, it does become a document in that there's a transcription of their spoken words. But just to emphasise that point earlier, councils, what's in the minds of a councillor is evidenced by what they say in the debate. So that's time constrained unless the mayor allows more time for each councillor to speak. So relatively speaking, it's quite a confined amount of time. And then whether they put their hand up for yes or no, that's the extent of the information that you're likely to have about the things that were most in their minds as they arrived at their decision. And I understand that might seem limited, and that is how decisions are made through council meetings. Okay, look, I'm going to thank everybody for turning up. Do take the comment about the fact it was during the day. We ummed and ahed on that one about what's convenient for people. We're trying to give people as much access as possible. Thanks for everybody online for joining us too, and others will watch this. You may watch some of this back again and replay certain bits. Please continue to participate in the process, as we've said, and the offer's always there from the planning team to field any calls or emails. We'll do our best to answer all of your questions there. Have a good day, everybody.